Good morning, everyone. I hope everyone's doing well this morning.
Good morning, Judge.
Good morning.
Good morning. Ms. Lewis, thank you for getting me all that paperwork yesterday. I appreciate it.
You're so very welcome, sir.
And we'll get started as soon. Oh, there they go.
Good morning, Judge Morrow.
Good morning. How are you doing this morning?
Pretty good, and yourself?
I can't complain. Thank you.
Whenever everybody's ready to start, we're going to be starting with positions number 17 and 18. Mr. Carlton Johnson.
That's a negotiated plea, I believe, Your Honor.
Yes, good morning, Mr. McLean. Thank you. Yes, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes. Speak up loud. Yes, sir.
Yes, thank you. Mr. Johnson, you've been charged in case 23 CR 003334E with battery and terroristic threats. And in case 23 CR 003335E with failure to maintain insurance and suspended or revoked registration. What are we doing with these this morning, Mr. McLean?
Your Honor, those are negotiated pleas. The only confusion was about the number of credit days on the case in which the state was recommending certain extra days.
Okay, I'll get Mr. Walker to clarify. Let me first swear in Mr. Johnson. Can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. Thank you, sir. Good morning, Mr. Walker.
Good morning, Your Honor. I see what Mr. McLean is speaking of. I believe that it's actually supposed to be 13 days credit instead of the 7 days listed on the calendar.
Yeah, he was thinking 13 or 14. He was hoping for 14, but that was what we were concerned about.
That was my error. I apologize.
No problem.
Offer on position 17, Your Honor, is going to be 12 months to serve 60 days. Credit for time served 13. Balance probated with the conditions of a 12-week anger management course. No further contact with the victim, whose name is Michelle Gilstrap, or I can spell that Gilstrap, and to stay away from 590 Cascade Avenue.
And for patient, go ahead. I'm sorry.
For position 18 is just simply 13 days time served.
Right.
17 more from jail. And then you start that. Your Honor, we understand and we ask the court to accept his negotiated plea of guilty as we stipulate to venue, identification, and factual basis.
Yes, Mr. Johnson, it's my understanding that in case 23 CR 003334E, you wish to plead guilty to battery and terroristic threats and acts. And in position case 23 CR 003335E, you wish to plead guilty to failure to maintain insurance and driving on a suspended or revoked registration. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Johnson. Good luck to you, sir.
Thank you.
Position 19, Ronald Johnson.
17. Oh, shit. It's on the floor. Oh, I got it right. Are you going to get the other thing? Yeah. Thank you. All right, thank you to meet you. Wow.
This is going to be a negotiated plea.
It is, Your Honor. This is number 19, death by taking one count.
Yes. Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes,
Okay, you can put your hand down. Thank you, Mr. Johnson. Mr. Walker?
Yes, Your Honor. The state's recommendation is 12 months to serve 32 days, credit for time served 16 days, balance probated with the conditions of a theft course, a stay away from the incident location, which is 2200 Godby Road, also known as Cranbrook Apartments, and no further contact with the victim, Mr. Terrell Garth, which is spelled Garth.
Mr. McLean?
That is, I believe, what we expected to hear in the way of terms, is it not?
absolutely.
So he asked the court to accept the negotiated plea as laid out by the state in the terms, and we stipulate the factual basis, identification, and venue.
Mr. Johnson, it's my understanding. I don't have the, Mr. Walker.
The date of occurrence, I believe, was 5/20.
No, I don't have the case number on my
I see that.
calendar.
I have it, Your Honor. It's 23 CR 003 304 B as in boy.
Okay, thank you, Ms. Walker.
Mm.
Mr. Johnson, it's my understanding under that case number, you wish to plead guilty to theft by taking, is that correct?
That's correct.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Absolutely.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I understand.
Has anyone forced or coerced you to plead guilty?
No, they haven't.
Okay, I will accept the plea as negotiated, Mr. Johnson. I'm gonna have the probation terminate once you complete the theft course. So the sooner you get that done, the sooner you're not gonna be on probation, okay?
Okay, thank you, Judge.
All right, good luck to you, sir.
Thank you.
Thank you, Your Honor.
Position 22, Mr. Roman.
It turns out, Mr. Walker,
Yes.
that was the case, not Mr. Edward Smith. It was Alvin Walker, in which I was wondering about the May 2023 allegation, the accusation there. We definitely need to get on the phone and discuss that one because of what his understanding is of the alleged victim.
Okay, I have the victim's name as Trudy Scott, and I have the incident date as May 27th, but I can give you a call when the court allows.
Very good. Yeah, we definitely have to discuss that one. We believe that well, we'll discuss that.
So, Mr. McLean, on this case, that's before the court now, is this gonna be an arraignment?
For now, it just has to be an arraignment, Your Honor. Yes.
Okay,
The defense, if we're correct on something, we're gonna have to prove with a document something.
okay. Mr. Roman, you've been charged in case 20 CR 003512J with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do waive it.
How do you plead, Mr. Roman? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Judge, also, Mr. Romans is on the add-on calendar.
Okay,
Got the other
thank
case.
you.
The,
He has a total of 3 cases on the calendar.
right, he has the FTA and also add-on number 1.
Okay, what are we doing with add-on 1?
That is the problem case, Your Honor. We would do an arraignment on that as well.
Okay. Mr. Roman, you've been charged in case 23 CR 003440J with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and $1,000 and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
Okay, we will. And Mr. Roman, how do you plead?
Not good.
We will record. Okay, thank you, sir. We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Okay, good luck to you, sir.
Okay, we'll stay in touch. Okay.
Positions 24 and 25, Edward Smith.
And these will also be arraignments, Mr. McLean?
Yes, Your Honor. Edward Smith, 2 cases. Arraignments.
Yes, good. Good morning, Mr. Smith. I'm Judge Eric Morrow. This is the state court all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Smith. Thank you. You've been charged in case 23 CR 003345A with battery, family violence, and in case 23 CR 003346A with criminal trespass and damage to property. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Mr. McLean?
We do waive that reading, Your Honor. We have copies.
Thank you. Mr. Smith, how do you plead, guilty or not guilty?
Not guilty.
We'll record your not guilty pleas. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, Mr. Smith.
All right, thank you, sir.
This is going to be on the probation calendar, positions 3 and 4, Mr. Rhodes.
They'll take you back. Your Honor, this is one where the issue is whether or not Victory Outreach would take him back. I'm sorry, well, through PAD. Through the PAD program, whether they would take him back. We reset it from 2 days ago. It turns out the answer is yes, because our social worker has been in touch with PAD.
Okay. Good morning, Officer Harris.
How are you?
I'm doing well, thank you. And good morning to you also, Mr. Rhodes. Remind me what this was about, Ms. Harris?
Mr. Rhodes, he hasn't reported to our office since he was sentenced back in 2021. And he just did to 2 more cases with our office. Those are going to be also my cases with Judge Porter. He had 42 days left to complete 8-week anger management, and I was asking to revoke his probation.
And how long has he been in custody?
I have no idea, Your Honor.
How long you been here? 26. Since the 26th of May, Your Honor. And he was asking the court to just terminate him on that so that he would go on to the PAD program. He had mentioned a coordination between Victory Outreach and PAD, so that was where I was saying that phrase.
Yes, the reason why I couldn't get in contact or do nothing that the courts required me because I was in Victory Outreach and I was also in Real Living Proof. And the rules and regulations that they applied, I could not leave. So they supposed to been handling everything for me. They supposed to been correspond with my probation officer, which they did. So now I'm in a new program. I only have like 6-7 days to terminate, to kill my probation on my own. But I'm asking the court to kill it today so I can be back in the program tomorrow.
Okay. I'd rather you be in the PAD program, Mr. Rhodes, so I'm going to sentence you to time served and that you're to be released to return to the PAD program, okay?
Thank you, sir.
So, Your Honor, I have a quick question. Since he already has 2 more cases with our office, how will we get in touch with him if the facility don't let him report to our office?
Is
Mr. McLean?
the other program the one that you had difficulty reporting from?
Yes, Victory Outreach.
But
will
this
be prepared.
this program you're in,
They will transport me to court.
Okay, he's saying the program he's talking about entering back into tomorrow will take him to court.
Okay, well, Your Honor, can I request him report to our office by Monday for concerning his other two cases with me?
Well, that's fine with me, but the only case that I have before me is this case where I've sentenced him to time served. I'm not sure. I can instruct him to do that. But I don't know if I can instruct him to do that as a condition of this, but you need to report to them as soon as you can, Mr. Rhodes. Let's say within the next 2 weeks for those other two cases, okay? Will you do that for the court?
Yes, sir.
Okay, so I believe that the time served I have is 11 days. Officer Harris,
Yes, Your Honor.
all right,
In jail-
very good. Good luck to you, Mr. Rhodes.
Judge, he's been in jail for 13 days.
Okay, 13 days, thank you.
And also, Ms. Harris, for the second case on there, do you submit a dismissal for that
Yes.
FT?
Yes, I can, Ms. Lewis.
Okay, I was just wanting to make sure, that's all.
And that concludes my business, Your Honor. May I be excused?
Yes, have a good rest of the day, Officer Harris. Always good to see you.
Position 3, Eric Smith.
That's add-on 3.
That's add-on 3. Is it add-on 3?
Yes, good morning, Mr. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. And this is going to be a negotiated plea, Mr. Dotis?
Yes, Your Honor, we would be requesting to enter a plea of nolo contendere.
May I get his history?
Yes, the defendant has
Yes.
a total of 2 cycles. He has a violate family violence order, and that was on 4/24/2023. And he also has a hold out of Atlanta for the simple assault. And that was on 5/27/2023. And nothing further.
Is the simple assault, that is, what did you say that? Is that open or closed?
It's like it's still open. It was on, the warrant was on 5/27/2023.
Okay, thank you. Mr. Walker?
I'm sorry, I got 1 second. My computer just froze.
Okay,
This is add-on 3, correct?
yes.
Okay, in this case, Your Honor, the defendant got into an altercation with a faculty or a staff member of Atlanta Mission. The defendant was someone who was receiving services at that program. He was asked to leave, and at that time, he struck the victim. Police were called, and he also threatened the victim. The victim's name in this case is Gregory Young. So we will be asking for a stay away and no further contact. And there's currently $1,000 surety bond. We just ask that bond is remain as said.
He's going to plead, Mr. Walker, I believe.
I'm sorry, I thought it was a bond hearing. So is it not negotiated or what's the issue?
There was a no-lo that was requested. That's why I asked for the history.
Oh, there's no yeah, that's fine, Your Honor. So the state's
Okay.
recommendation is 12 months to serve, 18 days. Credit for time served, 9 days, balance probated with the condition of a behavioral health evaluation. Stay away from the Atlanta Mission located at 156 Mill Street and no further contact with Gregory Young.
Okay, as there's no objection, Mr. Dotis, it'll be negotiated, correct?
Yes, Your Honor, thank you.
Anything further, Mr. Dotis?
Nothing, all right, Your Honor, we would ask this court to waive a few months of Mr. Smith's probation fees to allow him to get back on his feet. He is residentially challenged. This did occur at Atlanta Mission. He has a list of resources to help him get back on his feet. We would also request it to go non-reporting upon completion of the evaluation and any necessary treatment. And we do stipulate to the 3 elements for the purpose of this plea.
Mr. Smith, it's my understanding that in case 23 CR 003493A, you wish to plead no to battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
No.
No, sir.
Okay. You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading no to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead no?
No, sir.
Okay, I'll accept the plea as negotiated. Mr. Smith, I am going to waive 2 months of your probation fees to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation, okay?
Yes, sir.
All right, good luck to you, Mr. Smith.
All right. Thank you, sir.
Position add-on 4 through 7, Mr. Williams.
Yes, Your Honor, this would be a negotiated plea for Mr. Williams.
Okay, good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Good morning, sir. Yes, sir.
Yes, good morning, Mr. Williams. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir.
Go home.
Mr. Walker?
Yes, Your Honor, on position 4, the state's offer is time served 3 days. And on position 5, it's going to be time served 22 days, balance suspended with the condition of a stay away from the Greyhound bus station located at 232 Forsyth Street. 6 and 7 will be non-priced.
Mr. Doders?
Thank you, Your Honor. That's our understanding of the offer. We would ask this court to accept it and do stipulate to the factual basis, venue, and ID for the purpose of these pleas.
Yes, Mr. Williams, it's my understanding that in case 22 CR 008473E, you wish to plead guilty to obstructing highways, streets, sidewalks, or other public passage, and in case 23 CR 000871E, you wish to plead guilty to criminal trespass and theft by taking. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the pleas as negotiated, Mr. Williams. Good luck to you, sir.
Thank you. Have a good day, sir.
You also.
Position number 4, Robin Brown.
Oh, on this one, Your Honor, the state was requesting if he could be heard last. I believe it's a public indecency, so
Your
our
Honor,
defense obviously has issues with us.
Your Honor, I spoke with Mr. Jones on the chat. This should be really quick. We're just gonna enter plea not guilty and waive arraignment.
Okay.
Okay. Yes, good morning, Mr. Brown. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
No.
You do not wish to have your case heard by video?
No. Do I say, yeah, what?
If you want to just quickly waive.
Yeah, I want to wait, yeah.
Plead not guilty, can do it in front. We're not gonna address.
Can I just talk to him though about some stuff?
No. Can we go on mute for a second?
Yes.
Thank you. We're ready for proceed, Your Honor.
Okay, and so my question was, do you agree to have your case heard by video?
Yes.
Mr. Brown, thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, sir. Thank you. Mr. Brown, you've been charged in case
Your Honor,
20.
we are just waiving arraignment.
Oh, okay. I'm sorry. So it's my understanding that you're going to file a written waiver of arraignment, Mr. Dodez. As such, the case will be returned to the division judge, and Mr. Brown, you'll get notice of your next hearing date.
Like how long?
Thank you.
Okay.
I'll speak with Mr. Brown on.
Thank you, Mr. Dodez.
All right, appreciate it.
Position 28, Walker.
What's the announcement for Mr. Walker?
Your Honor, in Mr. Walker's case, we were hoping to hear from his other attorney. At this time, I would either want to reset it one more week or just go ahead with an arraignment, and we can always change that later if need be.
Okay, so I'm happy to reset it till next Thursday if you want me to, if you want. Is that what you're asking, Mr.?
There will be no harm in doing that considering his other situation, Your Honor. Let's reset that because the other attorney I've left, getting hold of. I will be getting hold of that attorney and asking him something. So, yeah.
Okay, that's fine. So we'll reset until next Thursday will be the 15th.
That'll be the best course. Thank you, Your Honor.
Okay. We'll see you next week, Mr. Walker.
Is Derek Mosley not here? He's going to be on video.
Who?
Derek Mosley.
I don't have to. So he's probably.
Number. I'm just waiting for.
Come on, Callaway. Position number 6, Callaway.
Still got that sheet I gave you?
And Mr. Callaway is a negotiated plea?
Yes, Your Honor.
Yes. Good morning, Mr. Callaway. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir, I do, sir.
Okay, you can put your hand down. Thank you. Good morning, Mr. Jones.
Good morning, Your Honor. On position number 6, the criminal trespass, the state's offer is going to be 12 months to serve 30 days, credit for time served 15 days, balance probated with a stay away from 5 Cleveland Street. For the theft by shoplifting, is going to be 12 months to serve 30 days, credit for time served 15 days, balance probated. The only difference is that anti-theft course.
Notice.
Thank you, Your Honor. We'd ask the court to accept the state's offer. We do stipulate to the factual basis, venue, and ID. As Mr. Callaway is residentially challenged, we would request this court to waive 2 months of his probation fees to ensure that he can get back on his feet and complete the anti-theft course. Additionally, we would request probation to terminate upon completion.
Okay. Mr. Callaway, it's my understanding in case 23 CR 003301Y, you wish to plead guilty to criminal trespass and theft by shoplifting. Is that correct?
Sir, I do, Mr. Morrow, sir. Yeah.
Are you under the influence of any drugs or alcohol this morning?
Sir, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am, Mr. Morrow.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do, Mr. Morrow.
Has anyone forced you to plead guilty?
No, Mr. Morrow.
I'll accept the plea as negotiated. I am going to waive 2 months of probation fees to help you get and stay on your feet. And when you complete the anti-theft course, the probation will terminate, okay? So the sooner you get that done, the sooner you're not going to be on probation, okay?
Thank you very much, Mr. Morrow.
You're welcome. And Mr. Dodos, I'm sure that you've already done this, but if you can assist Mr. Callaway with any, with the challenges that he's having to residents, that would be greatly appreciated.
Understood, Your Honor. Thank you.
Thank you.
Thank you, Mr. Morrow.
You're welcome. Have a good day.
Position 9, Freeman.
What's the announcement on Mr. Freeman?
Yes, Your Honor. This will be a not guilty plea, and we request a waive arraignment.
Okay. So a written waiver will be filed, Mr. Freeman. As such, you'll get notification of your next hearing date and the case will be returned to the division judge. Good luck to you, Mr. Freeman.
Thank you, Your Honor.
Good luck, Mr. Freeman.
Position 10, George.
What's the announcement on Mr. George?
Yes, Your Honor. After further discussing with my client, we'd request to go forward with a negotiated plea.
Okay. Good morning, Mr. George. I'm Judge Eric Morrow. This is the state court all-purpose calendar that we're conducted by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. George, you've been charged in case 23 CR 003277J with driving under the influence of alcohol less safe. Yes. And now, did I swear you in, Mr. Jones? I mean, Mr. George?
No, sir.
Okay, if you raise your right hand, do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, Mr. George. Yes, Mr. Jones.
Yes, Your Honor. So the state's offer is going to be 12 months to serve 32 days, credit for time served 16 days, alcohol, drugs, evaluation and treatment, a $300 fine, risk reduction class, and a victim impact panel.
Mr. Dodos?
Yes, Your Honor. That's our understanding of the offer and would ask this court to accept it. We do stipulate to the factual basis, venue, and ID for the purpose of this plea. Mr. George is residentially challenged and does not have employment waiting for him. So we would ask this court to waive all of his probation fees. I am going to provide him a list of resources to get back on his feet with housing and finding a job. We would also request for him to go non-reporting upon completion of all conditions of probation.
Okay. Mr. George, it's my understanding in case 23 CR 003277J, you wish to plead guilty to DUI less safe. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir. No.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. George. I will waive 2 months of your probation fees to help you get on your feet and get a job. And when you complete the terms of the probation, it'll go to a non-reporting status. Okay, good luck to you, sir.
Position 16, Gutierrez.
And this is going to be arraignment.
Yes, I'll answer that after court.
That was my understanding.
Yes, Your Honor, it's an arraignment. It's not guilty. This is not holding him in court. It's not on his booking sheet.
Okay, good morning, Mr. Gutierrez. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, sir. You've been charged in case 23 CR 003306C with stalking. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do, Your Honor. We have a copy of it.
How do you plead, Mr. Gutierrez? Guilty or not guilty?
Not guilty, Your Honor.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Thank you.
Position 3, Bowers. Position 21 is not cooperating, Mr. Mosley, so I'm not gonna fight with him.
Understood.
So is this is Mr. Bowers before me?
Yes, it is.
I have down, Mr. Dotis, that this is reset to the competency calendar.
Yes, Your Honor. This should have been.
Okay. Okay, so we don't need Mr. Bowers today. He's going to be reset to the competency calendar.
Okay, thank you.
Okay. And I'm sorry, I missed the last person that is not going to be brought. Can somebody tell me who that is?
It was Mosley, position number 21.
Yes, it's unfortunate, Your Honor. He was going to be offered time served, balance suspended, but apparently he's not got it together today.
Would you like to reset this till next Tuesday?
Yes, Your Honor, as soon as possible.
Okay, we'll reset it till next Tuesday.
Thank you, Your Honor.
Judge Morrow, the only case that I have left is the competency calendar. So it's only one person for the competency that I have.
Okay, do we have people in other places? What about position number 2?
Everybody else is gonna be on the floor.
Okay, all right, so
Yeah.
thank you. I appreciate it. So we'll just hold until somebody else comes on with us.
Okay, thank you.
All right, thank you.
Good morning, Judge Morrow.
Good morning, Ms. McLeod. I hope you're well today.
I am well, thank you for asking. I represent Mr. Bonds, who's number 2 on the calendar. I understand he's in another location. I do
Yes.
have someone in the mental health court that I need to check in with, so I was going to ask the court's permission to do that and come back.
Oh, yes, that's fine.
Thank you.
Yes, thank you, Ms. McLeod, for letting us know. Ms. Lewis, are you there?
Yes, sir.
We are going through this calendar pretty quickly. Could we see if we could get in touch with the people on the competency calendar, Mr. Howard, to see if they want to, if he wants to log in a bit early so we can get that calendar done?
Yes, sir.
Okay, thank you. I appreciate it.
Katrina, I'll try.
Oh,
Okay.
thank you, Ms. Graves.
You welcome.
Thank you.
Mr. Dotis, can you hear me?
Yes, Ms. Lewis.
I got a question for you regarding position number 3. I only have position number 8 that was supposed to be reset to the competency counter. Is there supposed to be a MHET done on position number 3? Because if so, I don't have it, and I didn't have no note that that person was going to the competency counter.
Position,
I just have position number 8 that was scheduled in the air for the competency counter. It was already on for 6/29, position number 8.
right, yes, position number 3, we're gonna request an MHET.
Okay, so you are gonna file one.
Yes, and we do need a date for competency. My apologies for not addressing.
That's okay. I just want to make sure I didn't get them confused. Yeah, I can give you a date. on that.
Okay, thank you.
Let's see, if he's just gonna file that now. 1, 2, 3. We're gonna have to go into the July the 6th.
Okay, understood.
I'm sorry, Mr. Dotis, I got one more question to ask you.
That's all right.
For position 11 through 15, any particular date, do you want me to set it to next Thursday for that particular person or no?
Next Thursday, if possible. Thank you.
Okay.
Yes, 4 North. Who do we have?
This is Mr. Sharp, position number 23.
There we go.
Yes, and what are we doing with Mr. Sharp today?
That's a negotiated plea, Your Honor. The only thing I lack is just, I'll gather it after the fact. It's going to be contact information worth a darn.
Okay. Good morning, Mr. Sharp. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I agree.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Mr. Walker?
Yes, Your Honor, the state's recommendation is 12 months to serve, 32 days, credit for time served, 16 days, balance probated with the conditions of a behavioral health evaluation and any necessary treatment, no further contact with the victim, whose name is Conrad Larkin.
Mr. McLean?
Your Honor, he asked the court to accept his negotiated plea of guilty while he stipulates to factual basis, venue, and identification. If it turns out the contact information is pretty slim, I must say to the court that because we had the contact booth and I was able to give him paperwork, we wrote notes about how important this report to 132 Mitchell Street reasonably soon in the next few days after he is released. So he has even if he has slim contact information, he does have the instruction to report to 132 Mitchell, second floor.
Okay. Mr. Sharp, it's my understanding that in case 23 CR 003310E, you wish to plead guilty to disorderly conduct and simple battery. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
Nobody's forced me to plead guilty.
Okay, I'm going to accept the negotiated plea, Mr. Sharp. Let's see, when you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation, okay?
Yes, sir.
All right, and you've gotten your instruction from Mr. McLean to report to the probation within the next 2 weeks, okay?
Yes, sir.
All right, good luck to you, Mr. Sharp.
Position number 20, Mr. Thomas.
That is also a negotiated plea. Two rounds. Got a couple rounds.
I'm sorry, what?
Thomas, number 20.
26.
Yeah, I'm sorry, I'm 26.
Okay, thank you. Yes, good morning, Mr. Thomas. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Yes, Mr. Walker.
Yes, the state's recommendation is 12 months to serve, 30 days, credit for time served, 15 days, balance probated with the conditions of a family violence intervention program and no further contact with the victim, whose name is Aaliyah Myers.
Mr. McLean?
Yes, Your Honor, this is from July 2022. We asked the court to accept his negotiated plea of guilty. He stipulates to venue identification and venue identification and factual basis.
Mr. Thomas, it's my understanding that in case, did you have a question?
Yes, sir. I want to change my plea because I ain't, like my daughter, I'm not guilty, so I don't know how we gonna do this.
That's fine. You're certainly entitled to change your mind, no problem. We could do an arraignment. We have
okay.
Accusation And if it's okay with my client, we'll waive a formal reading of it.
Okay, Mr. Thomas, you've been charged in case 23 CR 003320B with battery family violence. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. It's my understanding, Mr. McLean, that you're going to waive formal reading of the accusation. Is that correct?
Yes, Your Honor, we will.
How do you plead, Mr. Thomas? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notice of your next hearing date, sir. Good luck to you.
And Your Honor, bond is moot at this time due to other matters. So we don't have a bond matter today.
Okay.
Position 20, Mr. Kendall.
That's not guilty today, Your Honor. Number 20.
Okay. Yes, good morning, Mr. Kendall. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, and good morning.
Good morning, sir. Mr. Kendall, you've been charged. Can you raise your right hand for me? Do you swear affirm the testimony that you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down, Mr. Kendall. You've been charged in case 23 CR 003337G with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Kendall? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, Mr. Kendall.
Thank you.
You're welcome.
Hey, Mr. McLean, did position number 2, Mr. Bonds, was he done? On 5 South? Did anyone do him?
No, that's Miss McLeod's case, and we have not addressed him yet.
Okay.
McLeod needs to speak to him. Is that correct? Yes. Oh, okay.
Mr. McLean, Mr. Kendall has a question.
Let's see, he's on 4 North. Do you want to do a quick breakout, or do you want to?
No, he just want to ask about the bond. He don't want to talk about the facts of the case.
Okay, Mr. Kendall. Okay, hang on just a second. Is Mr. Fowler there? I don't see it.
Ms. Blunt,
Yep.
you know, McLeod's number?
No, I don't know her number.
She's in court right now with another case. She will log back on shortly.
Okay.
All right. Officer Norris,
Yes,
Duffy didn't show up.
he's here.
Is he gonna do the guy on 5 or not? Or do I need to go up there?
I gotta check.
Don't we still have position number 5 left?
Ms. Blunt,
Yes.
Duffy's gone for today.
Oh, okay. I'm glad I asked.
Yeah.
Have you got your option? No, I mean,
Judge, I'm only seeing 2 more cases left on the SAP counter, position 2 and 5. I know the whole is for 2 is, but what is the whole for number 5?
We, does anyone know if Jessica Bynum is going to be with us this morning?
Yes, Your Honor. I met with Ms. Bynum yesterday. That should be a negotiated plea. It says ACT on.
Okay, so we can see if they're gonna get her present, please.
Will you attend,
We're gonna try and get in contact with someone at ACDC, Your Honor.
Okay, so while you all do that, good morning, Mr. Howard. Are you on with us?
I am, Judge. Good morning.
Good morning. Would you like to go ahead and do the competency calendar now while we're waiting for the,
We can, Judge.
okay.
I don't have Mr. The one on Fort South. I gotta go grab him. I don't have him. I didn't bring him over yet, Mr. Grant. So I need to go get him because I didn't know he was gonna start this early.
Oh, okay. Are you gonna need him, Mr. Howard?
Yeah, for him, I prefer he be.
So are we done with Mr. Kendall?
I just want to know what.
Mr.
That was Mr. McLean's case.
Hold on. Yeah. Just hold on.
Derek.
Hello?
Hey, Derek. Can you hear me?
Yes.
Hey, good morning.
Good morning.
Hey, you got an email from Sedgwick.
Mr. Howard, you're not on mute.
Yes. I did. I responded, right after that and told him that, yes, she is back at work.
Okay.
Yes.
All right, thanks a lot.
No problem. All right.
On 4 North, is it possible for Mr. Kendall to call 2-2392?
I don't have a phone, McLean. That's why I'm at. He just want to ask about his bond. That's all. So I can go to another phone where this man.
After court today, as soon as I turn in my paperwork, I can come visit him on 4 North and show him his bond sheet.
Okay. We can do it on my laptop.
Oh, no, I looked it up. I already know it. I just need to convey it. I just don't want to do it for them, but. I'll go visit him.
Okay, thank you. All right, so we're holding on 2 others on the SAP calendar. So if we can, if once Ms. McLeod gets back on, if we can, and her client gets here, if we can go ahead and take care of her while Mr. Howard, we can do the rest of the cases while we're waiting on that particular person to join us. Is that fine with you all?
Yes, Judge, that'll be fine.
Okay, all right. So if we can all go into a breakout so we can do the start on the competency calendar, please.
And Your Honor, if I can request that the SG victim advocate, Gloria Maldonado, if she can be included in the breakout with us.
Of course, Mr. Walker.
Thank you. It says G Maldonado.
SG advocate, you said?
Yeah, G Maldonado.
Okay, thank you.
Thanks.
When you guys get back, FYI, this is going to be Mr. Kufu Ray in the chair.
And who is this? Tell me again.
Kufu Ray for the competency. And y'all guys.
Oh, okay. Thank you.
All right. You're welcome.
Mm. Mm. Tell Ms. McLeod that they're on in the competency calendar. She don't have to do that. They're gonna have her holding. And there she go. So I can let her know, Michael, that she can join back in. Hey, Miss McLeod, you're on mute.
Yes, yes. I was just coming back to check the status of things because I'm
Yes,
quite finished with my other client.
you said you're not finished?
Not quite finished yet.
Exactly.
Maybe another 10 minutes.
No problem. Yes, you can go back in because they're in the competency calendar right now.
Okay,
Okay?
great. Thank
And I'll
you.
let the judge know you're welcome.
Okay, bye-bye.
I have position number 11 on the competency calendar. Mr. Grant.
I'm sorry, what was that?
Position number 11 on the competency calendar, Mr. Grant.
Okay, he's here. Thank you.
Are they in the breakout room?
Yeah, Hank, yeah, they're in the breakout room. I don't know. if
Can
someone-
someone transfer me? Oh, yeah.
I don't know if Mr. Jordan or anyone from hosting the Zoom can help. That.
Is it, is there a Miss Twilight on the Zoom?
Miss Lewis, can you put me in the breakout room with them?
I thought you were in there.
No.
My name is Twyla. Yes, ma'am.
Twilight,
Mhm.
okay, I'm getting ready to put you in a breakout room
Yes, ma'am.
regarding your case. Ms. Grace, did you get that?
Yes, I'm doing it now. Thank you.
Okay, I just didn't want to double click.
That was Ms. Burgess, right?
Ms. Burgess and Ms. Owens needs to go into the breakout room.
And who else? I'm sorry, Katrina. Who else?
Ms. Owens,
Thank you.
top, you see her?
Mm-hmm.
Okay. There should be something popping up on your screen shortly, Ms. Owens, to let you in. And I'll put my own self back in. Oops. The jail, is Mr. Grant, is that him in courtroom 2? Courtroom 2? Hello? Courtroom 2?
Yes,
Yeah, is that Mr. Grant?
this is Mr. Ray for the competency, position 21.
Okay, it's Mr. Grant.
Mr. Grant, we're here up on 4 North. This is Grant right here.
Okay, I'm gonna put y'all in a breakout room, for Mr. Grant.
Okay.
I don't see Mr. Malik on
Okay, let's see, who do we have in courtroom 2 or at ACDC?
Yes, Judge, this is gonna be position number 21, Mr. Ray.
Okay, Judge, I can, yeah, Mr. Ray, we did talk about him.
Okay, so we need him in a breakout, Mr. Howard?
Yes.
Okay.
If no one's in the courtroom, we can just stay. Is there anyone else in the courtroom except our people, Ms. Francois?
Yeah, that's it. I'm the only one.
Okay, we can just do it there, Judge.
Okay. Yes, good morning, Mr. Ray. I'm Judge Eric Morrow. Mr. Howard, would you like to explain to
Yes.
Mr. Ray what we've spoken about?
Yes, Mr. Ray, you and I met yesterday and I told you that I'll be requesting for you to be released, but what's going to happen is the judge is not going to release you at this time. The process, the psychiatrists we talked about the evaluation that was requested for you. So once they submit their written report, we're going to revisit your case. So that we need to get that report before we can make a final decision can be made about your release. So your case is being reset a few weeks out too. What was the reset date, Ms. Lewis? Do you have?
I have July 6th.
Okay, so your case is going to be reset to July 6th. And at that time, we should have additional information that will help us to be able to make a decision about whether you can be released at that time. So
Can you just release it today? I come back, I'll do the evaluation on probation.
well, no, that's not really an option at this point to do probation. It's just at this point is we're not able to get you released today. So hopefully on the 6th, we'll have what we need and we can revisit it, and we'll ask again at that time if it's appropriate. But right now, we're not able to get you released today. So I just wanted to let you know that. And I'm going to give you that other information, when I see you, that you had asked about the case number and everything you needed about your property. So I'll get that to you as well. I didn't forget about that.
So y'all gonna make me miss 4th of July for criminal trespass?
I mean, at this point,
I think that's unfair.
Well, that's where we are, Mr. Ray. You do have a bond. You can post bond and be released. But in order to be released without the post a bond, you're going to be here, until at least the 6th. We'll revisit it on the 6th. But right now, you do have a bond on the case. So if your family were to post bond, you could get out. But short of that, we're going to have to talk about it again on the 6th. Like I said, I'm going to come and give you that information we discussed yesterday. But that's where we are. So I just wanted to give you an update and let you know that's what's going on.
And Mr. Howard, it's all right with the court if the paperwork comes in before then. I'm happy to entertain putting it on an earlier calendar. So if you'll just if you'll monitor that, and as soon as it comes in, I'm happy to revisit it.
Okay. So Mr. Ray, it could be before then, depending on when the report comes back. All right. So it could be before July 6th.
No problem.
All right. Thank you.
You're welcome.
All right. Have a good day, sir. And who do we have at ACDC?
Is Bynum before you, Your Honor?
I believe this position.
Position number five, Judge.
Okay, and this is going to be a negotiated plea?
Yes, Your Honor.
Thank you. Good morning, Ms. Bynum. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Mr. Jones?
Yes, yes, Your Honor. So the state's offer is going to be 12 months to serve 30 days. Credit for time served 15 days. Balance suspended. A stay away from 2273 Country Club Drive, Southwest Atlanta, Georgia.
Yes, Mr. Dotis?
Yes, Your Honor. That's our understanding of the offer. We do stipulate to the factual basis, venue, and ID for the purpose of this plea.
Ms. Bynum, it's my understanding that in case 23 CR 003300C, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Good luck to you, ma'am.
Thank you.
You're welcome.
Next, we have Ms. Floyd.
I believe this is position 8.
Yes, and what are we doing with Ms. Floyd?
Yes, Your Honor, this would be a plea. It may be non-negotiated. Our only issue would be restitution.
Are you all seeking restitution, Mr. Jones?
1 second, Your Honor.
Mr. Dotis, I had this case reset for 6/29 competency calendar. From the last time it was on the counter, that was requested. It was counted on this counter as an error. That's what I was informed.
I did not request this on the competency calendar unless,
From last week,
last week she was, she had another court date, which is why, she was downtown, which is why we reset it a week out. I did not request a 6/29 court date. I don't know if
okay, that's fine. That's what I had. That's what I was informed. But that's fine. I'll go get the file.
I had the court date was on the same day. I didn't, they said it was going to be scheduled a week later today, but it was on the same day. I had a behavior court date and I had.
Okay, hold on, Ms. Floyd. Let us figure it out. Thank you.
On the 6/1 counter.
So I'm looking into it, Ms. Lewis, but right now I see that she has some felony cases in Superior Court and it says accountability courts. So I'm trying to look further into that. But I think she has 2 felony cases and is in some type of accountability courts, which is
Right.
to the MH.
Are you still looking for the restitution, Mr. Jones?
No, Your Honor, I thought that we were trying to.
There's no restitution, but she is in behavioral health court on 2 different cases in Superior Court. So just want to make the court aware, but there is no restitution.
Okay,
And they did place Mr. Howard did put an order in on an MHET on May the 18th.
So we probably should not take this plea.
Right.
right, I agree. So where are we gonna place her?
Apparently from the June 1st counter, whoever operated that day, they had notes in here and they placed it on the 6/29 counter, opposite counter. So
Okay,
that's what's in the system.
all right, so Mr. Douglas, why don't we just leave it on that calendar?
that's fine, Your Honor. I guess she may have been on both calendars last week and we didn't catch it.
Okay, all right. All right, so we'll see Ms. Floyd back on the 29th.
Your Honor, I'll be back with Mr. Chauvin Hoover
Okay,
with his competency calendar. So give me a few minutes, please, okay?
okay, and when you come back, we'll probably be in a breakout room, so just ask to join the breakout room for me.
You want him in the breakout room?
Yes, that's correct.
Okay, we'll take care of it.
Okay, thank you.
You're welcome.
And just so I can let everyone that's not necessary go, we have, I understand we have position 2 still to deal with. Ms. McLeod, have you had an opportunity to speak with
I
Mr.
haven't.
Collins?
Because he's upstairs apparently, so I have called a couple of times, but I believe once the officer has dealt with her last client, then she will get him, so I can speak with him.
Okay, so Ms. Lewis, before I go back into the breakout room, would you mind going over the calendar so that we can release people that are not necessary for that calendar?
Yes, sir, I can.
Thank you.
Okay, I will start with the add-on calendar. Position number 1 on the add-on was defendant was arraigned. The case is set for trial further notice. Position number 2, the case is reset further notice. Position number 3 on the add-on counter was a no-load plea. And position number 4 was a time served plea. And position number 5 also was a plea. Position number 6 and 7 will be null pros. Okay, the regular counter. Position number 1, defendant was released. The case is reset further notice. We're still holding on position number 2. Position number 3 is reset for the competency counter for July the 6th. Position number 4, defendant waive arraignment. Case is reset for trial further notice. Position number 5 was a plea. Position number 6 was a plea. Position number 7, defendant was released. Case is reset further notice. Position number 8 is reset for 629 competency counter. Position number 9, defendant waive arraignment. Case is reset for trial further notice. Position number 10 was a plea. Position number 11, 12, 13, 14, and 15 is going to reset to the SAP counter for June the 15th. Position number 16, defendant was arraigned, not guilty. The case is reset for trial further notice. Position number 17 was a plea. 18 was a plea. 19 was a plea. Position number 20, defendant was arraigned. Case is reset for trial further notice. Position number 21 is going to be reset for Tuesday SAP counter, which is June the 13th. Position 22, defendant was arraigned, not guilty. Case is set for trial further notice. Position 23 was a plea. Position 24, defendant was arraigned, not guilty. Case is set for trial further notice. Same announcement on 25. Position number 26, defendant was arraigned, not guilty. Case is reset for trial further notice. Position 27, defendant was released. The case is reset further notice. And position 28 is reset for the SAP 615. Any questions or concerns?
And we got the 5 Sal.
Position number 2, Kendarius Bonds.
Okay, we're gonna put Mr. Bonds and Ms. McLeod into a breakout room. Is that fine, Ms. McLeod?
It is, Your Honor. Thank you.
Okay, Judge. And that's courtroom what?
This
It's
is
5
South.
And I see that Mr. Mondelli has joined us. Good morning.
Good morning, Judge. My apologies for being late. I had this down for 11:30 on my personal notes. My apologies.
Oh, no worries. Let's see. Can we go back into the breakout room?
Okay, Judge, with everyone that was in before?
Yes, please.
Okay.
Flo, the jail, anybody there from the jail?
This meeting is being recorded.
I was just trying to see if Mr. Christopher Schunhofer was in the gallery yet. Anybody knows?
Asking Miss Lewis?
I was asking if Mr. Christopher Schunhoff is in the gallery. Did they go and get him? Because we need to have him in the breakout room. It's on the competency calendar. He's position 24, 25, and 26.
I was told to only get 2 people for competency. And that was Mr. Ray. And the other one was, I believe it's Talit. I don't know his last name.
I think we already dealt with the other one. I think the only person we need left is the Christopher Schunhoff. So the nobody.
I wasn't told to bring him, Ms. Lewis.
Okay, I'll let Mr. Howard know that.
Okay.
In the meantime, y'all, Ms. McLeod, you ready with your client?
Yes, I'm ready.
Okay, I'll let them know. Give me 1 second.
Okay, we're ready. The internet went out. Fire South is ready.
feet was hurting and stuff like that.
Yes, Ms. McLeod, have you had an opportunity to speak with Mr. Bonds?
I have, Your Honor, and he is interested in the state's plea offer. I would just like to state that I did check on this case this morning in Odyssey, and I see where one of the charges that is still showing up in the offer was dismissed, was NOD'd. So I would like that the cruelty to children charge was NOD'd.
It
Yes.
was not pros. It was not pros. I was not pros.
Yes, it was now processed yesterday.
Okay, so there's only one cruelty and one battery family violence?
No, Your Honor, I think the cruelty was, I thought the cruelty was dismissed.
It was, the cruelty to children was, I received a not pros already signed off by Judge Law on the other day.
Okay, so I guess I'm just saying, I have 2 cruelty to children on my calendar. Were they both dismissed?
I
Oh, I'm sorry. No. I'm looking at the, all right, so simple battery family violence and simple battery against a person 65 years or older or who was pregnant.
Right, that was my understanding of what is outstanding, because
That's correct. That's correct.
Okay, all right. And he wishes to accept the state's offer?
He does, Your Honor.
Okay. 5 South, if you can unmute for me. Good morning, Mr. Bonds. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Mr. Walker?
Yes, Sean, the state's recommendation is going to be 12 months to serve 12 months to serve 45 days. Serve 14 days. Balance probated. No further contact with the victim. I want to spell her first name, Mashilyn, Hemphill. With the conditions of a family violence intervention program and to stay away from 324 Fairburn Road in Atlanta, Georgia.
And that's for both charges?
That is correct, Your Honor.
Okay. Ms. McLeod?
That is our understanding of the terms of the plea offer, Your Honor.
Mr. Bonds, it's my understanding that in case 23 CR 003323F, you wish to plead guilty to simple battery family violence, simple battery against a person who is 65 years or older or who was pregnant at the time of the offense. Is that correct?
Yes.
I'm sorry, is that a yes?
Yes, sir.
Ms. Gilbert, hold on with Judge, hold on. Okay, go ahead, proceed, I'm sorry.
Okay, no problem, thank you. Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
Okay, I'll accept the plea as negotiated, Mr. Bonds. Good luck to you, sir.
Thank you.
And Ms. McLeod, I guess I'll see you next time if you have no further business before the court.
Thank you, Your Honor.
All right. Okay. Have a good day.
You too.
Okay, so now I guess we'll wait for Officer Melton to come back.
Your Honor.
Yes.
Okay, I went to get the inmate. He refused to put on a white shirt. I told him he has to come to court in uniform. He said he has never gone to court with a blue shirt on, and he refused to abide by the rules and that we have set for him. So what you want me to do?
Then Judge, I'm fine with the argument. We talked at length yesterday, and I know he's had a thing with the blue shirts before. But I'm prepared to argue without him being here. I told him that we would be, what would be happening. So, and I'll
And the state's position is if a waiver of appearance has not been found, I don't think it's proper to go forward without the defendant.
And Judge, I can file a waiver. Could you?
But I
could you
think he
get
has to
a
give you
phone
his
from me, Miss-
permission.
Can you get a
to file
phone
waiver.
from me, Miss Milton? Can you get
If
him
I
on the
can-
phone
All right,
like you did with the other ladies?
okay. What number, you want me to call you on your
Yeah,
cell
on
number?
my cell. Yeah.
Okay, will do.
Since Mr. Walker stalled him, he stalled me.
Well, of course, my argument
I'm
is
gonna
he can't follow simple rules. Well, how is he going to follow the
Well,
conditions?
people he has some beliefs that are different from ours.
That's the
And
problem.
one of the things, coming across the threshold of the bar. and-
Hold on just 1 second. While they're arguing, Officer Milton, would you mind going and seeing if we can get him?
Yes.
Yeah,
Somebody go
okay.
on? Or
Because I have an 11:30 court pre-indictment calendar that I wanted to do, but I take care of it.
Yeah, if you
Okay.
just call me, Miss Milton, on my cell like you did with the ladies, and I'll talk with her.
Y'all get me a phone.
Thank you. Okay, continue.
So he does have some beliefs that are different from ours, but in the end, I mean, he wasn't being combative, but he just believes, certain things very strongly, and he's committed to those beliefs. But at the end of the day, I'll talk with him and let him know that I can argue for his release without him physically being present, and see if he'll agree to that.
Okay. So just let us know, Mr. Howard. We'll just.
Okay. All right.
I will hold for your report.
All right. Thank you.
Mr. Howard, Your Honor. Mr. Walker,
Yes.
okay, this is what's going on. He refused to come out to put on with a blue shirt on. They have to set a precedent that if they do one, let him come out and use the phone down there, then somebody else will make a big noise about it that, well, if we let you do, if they can do that, then I can do that. So I would suggest that if you come down, get the paperwork, have him sign the waiver, because the officer has to set a precedent for everybody in there. And the reason why you got an opportunity to talk to those two ladies is because I went and got a phone. And I borrowed the lieutenant's phone, which is the county phone. So I
Okay.
cannot go back and forth you asking them.
Okay, Judge, are you doing the 2 o'clock calendar? I'll go out to see him, and I'm gonna go see Mr. Owens, and I'll go by ACDC and see if I can get Mr. Shonifer, to agree, and then, if so, I'll we can, Ms. Walker, you available to jump on to just address it at 2?
No.
Come
I will
on,
say
Mr.
this, in
Walker.
position 26, he's already released. Position 24, I don't know if you saw this or not, his bond was revoked and he was given a bond through pretrial services and he was
Right.
ordered to home confinement. So I'm not even sure if it's necessary. I haven't had the opportunity to look at position 25, but he's already had a revocation here in front of Judge Taylor, and Judge Taylor gave him a bond through pretrial services, but
Well,
on home confinement due to the revocation hearing. So I don't even think it's appropriate at this time, since a revocation hearing has already been had and Judge Taylor has already issued a ruling. I really feel like he's being held on his felony case, because he has 4 open cases.
Mr. Howard, why don't we do this, if you'll agree? You take a look at everything that Mr. Walker said. We can put him back on for next Thursday's competency calendar, so that you have the opportunity to address everything that Mr. Walker's saying. Because I don't know if 2 o'clock will give you enough time, but you tell me.
May I say something, please? The officer that is in there, he's sticking to his rules. If he refused to come put on the blue shirt, he's not coming out, not even for free time. So
what are you saying? I mean, if I come and ask for a visiting attorney booth so that I can get his consent to waive potentially, like I talked with him yesterday in the attorney.
did he have on a white shirt?
I can't remember. It may have been white. I can't remember what color shirt he had on, but
Sometimes it all depends on the officer. But when you got one that abides by the rules and regulations, then just like Mr. Ian Walker, he's sticking to his guns. So the officer is doing the same thing.
And I just checked, Your Honor, I'm sorry to interrupt, but he's only being held on position 24. A revocation hearing was held and he was giving a bond through pretrial services. So technically he has a signature bond. I will say a condition of that bond is home confinement. So once someone's bond has been revoked and modified by a division judge, then to bring it back to the SAP calendar to ask that bond to be reconsidered, I really don't think that's appropriate. He's had a revocation hearing and the judge, his division judge has issued an order, albeit on a pretrial services bond. I don't know what we're discussing, quite frankly. And he's being held on a felony no bond. So like,
no, he's
yes, he is. I just looked it up. He's being held on a felony no bond.
All right.
So I don't know.
Which one you believe he was that it revoked on 21, you said?
Position 24.
And what was the hearing date?
Let me go back because I'm on the gelling screen. I'm sorry, I got so many different screens
Your
open.
Honor, I have to get to my 12 o'clock.
Okay, thank you,
Okay.
Officer
right.
Melton. We appreciate it. Thank you.
No problem. Bye, everybody.
Okay. Am I gonna see you this afternoon?
I don't have anybody there,
Okay.
but
all
I
right.
have 5 o'clock course, so I have to stick around.
Have a good rest of your day. Thank you.
Thank you. Bye-bye.
My Odyssey froze, but I can tell you the exact date in maybe 15 seconds. Let me log back in.
Judge, did you still need pretrial?
I don't think so. Thank you, Ms. Boxley Chester.
Thank you, Judge.
Yeah.
Good day.
Thank you.
Just 10
Are
seconds.
you referring to the order the judge,
Taylor,
notified? Yeah, it was filed on it was filed
I'm gonna
filed
tell
on on March the 8th of 2022.
right, and he was given a pretrial services bond with the condition of home confinement. So,
Yeah, there was a lot of conditions in here.
Well,
Right.
I mean, but that is a, that was March 8th of 2022. He hadn't been,
right, so he's technically
he was
being
only
held.
arrested at this, he's been out on that already. I
But
mean,
that's my
he's only
point is
been-
he's being held on his felony case. He has a pretrial services bond on this case.
I don't see this felony case on his booking screen that you're referring to. What is, I'm not showing on his booking screen any felony case.
I'm showing it on his booking. Well, you have me going from screen to screen, but hold on.
I'm showing,
It says criminal, it says no bond.
well, I mean, that was from the original, I guess bench
Those
warrant.
are the
It's
ones
bench
for
warrant.
bench warrants for Judge Taylor.
Right, these are bench warrant cases, not right. He's not being held because of he's been.
Okay, so it just
picked
says
up on
no
bench
bond.
warrant.
So technically but that doesn't matter.
No, I think he was let out on what you're referring to, because obviously he's been out till December of this year when he got picked up on a bench warrant, and he's been in since then.
I don't
So,
think he got
like-
picked up on a bench warrant because he was arrested 3 days back to back. He has 4 open cases. He was arrested back to back to back.
He's been in the Fulton County Jail since December 22nd of 2022. I don't know what you mean. He got out February the 5th, and he was rebooked into the Fulton County Jail on December 22nd. So this order you're referring to, the way his bond was revoked, has already been dealt with. He got out pursuant to that. He's back in custody since December on that case. You know, the
So
20
he's being held on position 25.
Right. So that's why we were asking, because he's been in 169 days on that. He had the eval done and all that. And so, I mean, yeah, so I just think it's the same request, but I'll go out. I want to try to see if I can go get a waiver, potentially to address it, today, since we're here, since, I talked with him last night. I didn't,
And I guess the state's position is he has 3 open cases in state court. Judge Taylor already revoked one of his bonds, albeit he gave him a signature bond with home confinement. I would ask that. I think it's appropriate for Judge Taylor to make a ruling on his other open case. That's my position.
I don't agree. He was released from,
Open case I'm sorry, Mr. Howard, is the other open case the criminal trespass alone, or the criminal trespass and obstruction?
Right. There's a criminal trespass that
His
Mr.
position 25 was holding him.
Okay, and what is his bond currently on position 25?
It's now see.
I have that it's $2,500 surety.
Yeah, it's actually positions 24 and 25 that he's being held on
No, he was given a pretrial services bond on 24, Derek.
previously, but that's resolved.
Right, so no,
So
his
he's back.
bond was revoked on 24, and they gave him a pretrial services bond with the condition of home confinement.
And he got out of jail. So right, that was way back in March. This week he wasn't in custody again until December. So you referring to an old issue. He's already resolved that matter. He's being held now on a bench warrant. I'm showing on the front of the jailing screen that on position number 24, he has bonds of 7,000 on the criminal trespass damage, 7,000 on the stalking misdemeanor, and 7,000 on the criminal trespass on position 24. So $21,000 bond on position 21. On position 25, 24. On position 25, I'm showing that he has a $2,500 bond on that criminal trespass. So these are bench. He got picked up on a bench warrant on both of these. He's been in custody almost 6 months on both of them. So I mean, it's not
Okay,
something.
we'll go with your argument, and I just ask the court to do what it always does with any case, for it to send back to the division judge to make a final determination, especially in the light that his bond had already previously been revoked prior to this. So his bond has been revoked. He was given a pretrial services bond, and then he bench warranted again on 2 other cases. So in any other case, it would be sent back to the division judge. So I mean,
No, we address bonds all the time. And Judge
no,
Edie,
that's
as a
not
matter of
true.
fact, the issue with Judge Edie should be resolved, because I don't know, Judge, have you gotten anything from Judge Edie about this notion that his bonds can't be touched? He is not in agreement with that. He was going to send an email to the SAP and the other judges to make them aware that they don't have to send every time his case comes up back to him, because we had Ms. Giddings, myself, and the judge had a conversation about this about a month and a half ago, because it was just meaning that people were languishing because Judge Edie's calendars are stacked. And it's
Okay,
difficult.
well, let me just say,
Yeah.
I don't have any I've not heard that, but I have had conversations with the chief regarding the procedures that I have of returning to if the division judges have made a determination on a bond that I return it to them if they come before me. That has been the policy and the practice, and I have specifically myself had that conversation with the chief. So if you're telling me that this is Judge Taylor's case, then until I hear anything different from Judge Taylor, and if Judge Edie wants to handle his cases different, if he'll inform me, I'll be happy to do that. But as far as this goes, and me knowing what you're saying now regarding Judge Taylor, and he's already made the determination, it would be my inclination to go ahead and send it back to him. If he wants to change his bond, he can do so.
And so in light of that, I guess I would ask me put on next week's SAP calendar so that he can do a not guilty, presumably, and then I guess the case would go back to Judge Taylor's courtroom.
Okay.
If the court is not inclined to address bond at all.
This place on the calendar that you're presiding over, Your Honor.
What was that?
I just asked that it's placed on the calendar that Judge Morrow is presiding over, because I don't want to be assigned to a different judge, and then we're back at square one.
Unfortunately, I've got the trial calendars next week, so I'm on the Orchid trial calendar all week, and will not be on any other calendars. I will have an SEA calendar Monday afternoon. If you all want to try to sneak on that calendar, but Mondays are generally, the SEA calendars are,
right.
Yeah, right. So,
Judge, I mean, we can just put it on next Thursdays, and I can let Angelo and Mike know that. I mean, I'll be there anyway for competency, but if Your Honor is deciding that it's got to get back to Judge Taylor in this instance, then I'll make sure that it's clear that we aren't addressing bond. It's just a matter of
as long as you remember.
What was that?
As long as you remember, I'm okay with it.
Yeah, Mr. Shaw. Don't forget Mr. Shaw.
That's Morrow.
Yes.
So everyone understands, he is holding with no bond. The bench warrants that he was arrested on lists no bond. So he has no bond dollar amount on either one of these charges. And he's been holding in jail ever since December with no bond.
And it's odd, Michael, because I'm looking at the first jail screening that has bonds amounts on these, but when I click on,
Right, if you click on it and you go to the actual charge itself, it says hold without bond. So he doesn't have a bond listed on either one of these charges. And when I went and looked at the warrants had no bond listed on the warrants. So I didn't notice that before, but he's been holding ever since December on these warrants, and both warrants have no bond listed on. So I don't know whether a second chance bail cashback 2,500 surety.
right,
I don't know if the bonding company surrendered him and they paid them the money back and that's just the entry they put. But the bench warrants have no bond listed on it. So if you click on each individual charge, each charge says no bond listed. Yeah, so the bonding company surrendered him and they paid them the cash back. I'm guessing that's what that cash back
Yeah.
is. So he is currently holding without a bond on every one of those charges. And he's been sitting there ever since December for 169 days. And I never noticed it before. Because I thought the same thing you said, where a second chance bail bonds, but then I was trying to figure out why he was still sitting in jail if he actually made a bond. So the bonding company surrendered him and he's been holding without no bond since December.
Well, my response to that is, at the very least, I ask that a due bond be set in the previous amounts.
I mean.
You,
Yeah,
you wouldn't.
I would ask that the bond, if it's not as it appears on the booking screen, that it would be updated to reflect those amounts that I'm seeing on that first booking screen of 7,000 on each of the charges on position 24, and then 2,500 on position 25.
Well, that was a 7,000 total bond. That's what they were trying to say, that they paid the bonding company.
Oh, okay. Let me see.
Total.
Yeah. As long
So
as they're
then-
surety bonds, I'm in agreement to resetting them to.
Right, and he, you know, he thought it was, I mean, he, right, so he wouldn't be able to make it, but those, right, if we can set them to judge, I guess. What, criminal trespass damage? 3 on the stalking. And then, I guess, 1,015, or they want, whatever that would be, 3, 2, and 2, however, you know, it's 3, 2, and 2 will be fine, I guess. To make it a total $7,000 bond on position 24, and then a $2,500 bond on position 25, so it'll at least reflect what it looks like it was on the booking screen. And then any further modification, I guess we'll have to see if Judge Taylor can, you know, that'll be addressed in Judge Taylor's supervision. Yeah.
Well, I'm happy to reset them if that's appropriate. Don't we run into the same issue as in regards to having this hearing without him present though?
I guess in theory, yeah, you're right, Judge. I mean, I need
So-
to get him to consent, but okay, I still need to, I guess, go see him. But I'll
Okay.
so that we can at least do that today.
Okay, so if you can get your waiver, then I'm
Okay.
happy to reset the bonds back to what they were.
Oh, okay, all right.
That's what Mr. Walker is.
Yeah, and I will consent via
objecting to.
email. I will consent via email if the court allows it.
Okay, so let me know it too. Well, whatever. The SEA calendars it too. So if you all come on and you tell me that you know that you have a waiver and that you're in agreement, then you can send the paperwork over to Miss. I'm not sure who's going to be on the calendar this afternoon, or you can just send it to Miss Lewis.
Okay, all right.
Okay.
I'll work on that.
Are we complete?
I think so.
I think so. Only thing I'm waiting for is those non-pros, Mr. Walker, make sure they are correct.
They were on the competency calendar. I didn't forgot what I even owed you.
The competency counter, and I need some on the regular SAP counter too, sir.
Okay, I'll take, yes, I'll do that right now.
Y'all trying to make me not get any lunch before my next calendar.
This Walker.
Small calendar.
All right, I'll see y'all at 2.
But Mr. Howard, please don't send those orders like at 4:45 and 5 o'clock.
I know I gotta go to the jail to try to get, but I'll try to send them. I mean, Judge Morris is gonna sign them, right? So I'll have them by the time, before he's off the bench.
Okay, thank you.
All right.
All right, Judge, and I get the rest of the paperwork to you in a
All
time.
right, I appreciate it.
All righty, bye-bye.
Yeah, thank you.